Welcome to another lesson in federal civil procedure. This video is part 2 of a two-part series on diversity jurisdiction, where we will be going over jurisdictional amount. And the reason why it has its own video is because there are intricacies of this topic that are so perfect for testing, especially in relation to aggregation of claims and supplemental jurisdiction. So in this lesson, I'll be doing a very quick and very basic overview of aggregation of claims and supplemental jurisdiction as well. And this reminds me, do not forget to watch my full videos on aggregation of claims and supplemental jurisdiction. Diversity jurisdiction goes hand in hand with supplemental jurisdiction. Let's go. Okay, so let's go back to 28 U.S. Code 1332A. Which grants the federal court's original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs. So in this lesson, we're covering this part right here. Matter in controversy exceeds the sum or value of $75,000, exclusive of interest and cost. It sounds simple enough, right? But as you know now, there isn't anything simple with law. So let's dissect it. And here's the rule. Actions brought in federal court under the diversity statute, not just actions brought in federal court, in excess of $75,000 exclusive, so not counting interest and cost. And there's a lot to unpack here. First, and most importantly, if you have a claim or a lawsuit for $74,999, this does not meet the jurisdictional amount. If you have a claim for $75,000, this still does not meet the jurisdictional amount. It has to be for more than $75,000. Please be attentive of this on your exam. Important points about amount in controversy. I want you to pay attention to all the stuff I'm about to tell you and to show you. I do not want you getting mixed up on your exam. The plaintiff's complaint determines the amount in controversy. First, we're going to talk about the plaintiff's complaint. So, the amount of controversy is determined by the court through the plaintiff's complaint. And that's how the court determines the jurisdictional amount, from the plaintiff's good faith allegation in the prayer of the complaint or allegation of damages. The prayer of the complaint is your request for relief. And I want you to remember this term because this is a legal term that I want you to use. Good faith allegation. You're going to see that term come up again. The plaintiff does not need to itemize her damages. So a good faith allegation that the matter in controversy exceeds $75,000 is sufficient. The plaintiff does not need to give a detailed accounting of how she arrived at this amount, so long as it's done in good faith. That's all they have to allege, that the matter in controversy exceeds $75,000. So what about counterclaims? Technically, a counterclaim is really truly a complaint, right? Because a counterclaim is when the defendant is suing the plaintiff during the same lawsuit the plaintiff originally filed. The question is, can a counterclaim be combined with a plaintiff's complaint to meet the amount in controversy? And here's the rule. A defendant's counterclaim cannot be combined with a plaintiff's claim to reach the jurisdictional amount for purposes of diversity jurisdiction. So the answer is no. A defendant's counterclaim cannot be combined with a plaintiff's claim to reach the amount of controversy. Plaintiff sues defendant for $74,000 and there's diversity between the parties. Defendant counterclaims for $5,000. Does the federal court have subject matter jurisdiction over this lawsuit based on diversity jurisdiction? And the answer is no. $74,000 does not meet the jurisdictional threshold, and defendant's $5,000 counterclaim cannot be counted to meet the amount in controversy, the jurisdictional amount. What about here? Plaintiff from Texas sues defendant from Iowa. There is diversity of citizenship, right? And the lawsuit is for $75,000. In this case, does the federal court have subject matter jurisdiction over this lawsuit based on diversity? And the answer is also no. Remember, the amount in controversy for diversity is in excess of $75,000, not $75,000 even. That was a little bit of a trick question. I just want to make sure you're paying attention. So this would not work. What about here? Yeah, this works. We already decided that the counterclaim cannot be combined with the plaintiff's claim to reach the jurisdictional amount. So the next question is, does a counterclaim have to meet the jurisdictional amount on its own? This counterclaim here is only for $5,000. Can it be asserted by the defendant? Is it exempt from having to meet the amount in controversy? Well, it's going to depend on whether the claim is compulsory or permissive. Let's expand on this. Let's first talk about compulsory counterclaims. A compulsory counterclaim, one arising from the same transaction or occurrence as the plaintiff's claim, need not meet the jurisdictional amount requirement. Because since it arises from the same transaction or occurrence, then it means it derives from a common nucleus of operative fact, and thereby the court can exercise jurisdiction over this claim via supplemental jurisdiction. Please don't forget to watch my full lesson on supplemental jurisdiction. So, for compulsory counterclaims, we don't require the defendant to meet the jurisdictional amount. In this scenario here, if the counterclaim arises from the same transaction or occurrence as a plaintiff's cause of action, then it need not meet the amount in controversy of over $75,000. In this scenario, the court has subject matter jurisdiction over this $5,000 claim. Now let's talk about permissive counterclaims. A permissive counterclaim, one arising out of an unrelated transaction or occurrence as the original claim, must have an independent jurisdictional basis. It must meet subject matter jurisdiction requirements on its own. So, in diversity cases, it has to meet the jurisdictional amount requirement. A permissive counterclaim is one that arises out of an unrelated transaction, and this is actually why it's permissive. Sometimes, for the purposes of judicial efficiency, the court will say, okay, you both have different issues that you're suing each other on, and they're not related, but we're already in court. I'll let you counterclaim with your unrelated claim against this plaintiff. And if that's the case, if that's what you got going on, the court would not have subject matter jurisdiction over this $5,000 counterclaim. This counterclaim would have to have an independent jurisdictional basis for federal subject matter jurisdiction. So either it needs to meet the amount in controversy, it needs to be a federal question, or a lawsuit under trademark law, copyright infringement, any federal jurisdictional basis. Okay, let's recap. Can a counterclaim be combined with the plaintiff's complaint to meet the amount of controversy? A defendant's counterclaim cannot be combined with the plaintiff's claim to reach the jurisdictional amount. Does a counterclaim have to meet the amount of controversy on its own? It's going to depend if it's compulsory or permissive. If it's compulsory, it does not need to meet the jurisdictional amount requirement, right? The court may hear it under its supplemental jurisdiction because it arises from the same transaction or occurrence. A permissive counterclaim must have an independent jurisdictional basis and thus must meet the jurisdictional amount requirement. Okay, so how is the amount in controversy determined? I want you to pay attention to this next part because it's regularly tested. And here's the rule. The amount in controversy is determined from the complaint itself, unless it appears or is in some way shown that the amount alleged in the complaint is not claimed in good faith. Now, pay attention to this next part, please. When a plaintiff pleads in good faith an amount in controversy above the jurisdictional threshold, a court will recognize a rebuttable presumption that the amount in controversy requirement has been satisfied. A rebuttable presumption is an assumption made by the court that something is taken to be true unless someone comes forward to contest it and prove otherwise. An excellent example of a rebuttable presumption, and I'm just trying to explain the concept here, is, for example, in Florida, when a couple is married legally and they have a child, the child is presumed to be the biological child of the husband. The state doesn't ask for a DNA test, to issue the birth certificate. There's a presumption of paternity, but this presumption is rebuttable. It means that someone else can come forward and say, excuse me, I'm the real father of that baby. And then this person who's contesting this presumption, this benefit of the doubt, they're in charge of proving that they have paternity. This person may request a DNA test, and prove to the court that he is the biological father. So that's what a rebuttable presumption is. And that's what's happening here. When a plaintiff alleges that his or her claim is above the jurisdictional threshold, above $75,000, the court is going to presume that she is correct. But this presumption is not ironclad. The defendant can come forward and contest it. But now the burden of proof is on who? On the defendant. So while we're on that note, let's talk about contesting the amount in controversy. What if the amount in controversy seems inflated? Well, procedurally, the defendant will file a motion to dismiss for lack of subject matter jurisdiction. Why? Because if the amount in controversy doesn't really meet the jurisdictional threshold, then claimant does not meet the requirement for diversity and the lawsuit must be dismissed. Unless, of course, there's another federal jurisdictional basis like federal question or trademark or copyright. And this is why a defendant would file a motion to dismiss for lack of subject matter jurisdiction. And once that's filed, now the defendant has to overcome the hurdle of the burden of proof. So defendant is the one that has to overcome this rebuttable presumption. And to overcome it, the defendant must show to a legal certainty, that's the burden of proof, to a legal certainty that the amount recoverable does not meet the jurisdictional threshold. Let's look at an example. Plaintiff from Colorado sues defendant from Texas. So we have diversity of citizenship, right? The lawsuit is for $76,000. So presumably the plaintiff meets the amount in controversy, right? But let's say that defendant disagrees. Defendant disagrees that the plaintiff's cause of action amounts to the alleged amount in controversy. So defendant will file a motion to dismiss stating that the plaintiff's case is not worth more than $75,000. And now defendant has to prove this. So now we know who has the burden of proof, right? And what is the burden of proof? I'm about to tell you the rule. The rule is that it must appear to a legal certainty that the claim is really for less than the jurisdictional amount in order to justify dismissal for lack of subject matter jurisdiction. So what does this mean with respect to the jurisdictional amount in diversity actions? Which is it? Is it that plaintiff must prove to a legal certainty that the amount in controversy is satisfied? Or is it that defendant must prove to a legal certainty that plaintiff does not satisfy the amount in controversy? And the answer is the defendant must prove to a legal certainty that the plaintiff does not satisfy the amount in controversy, if he or she is contesting it, right? And this comes from the St. Paul Mercury case, also known as the St. Paul Mercury test. I will read the relevant part. The rule governing dismissal for want of jurisdiction in cases brought in federal court is that unless the law gives a different rule, the sum claimed by the plaintiff controls if the claim is apparently made in good faith. There's that term again, in good faith. If you're dealing with this situation, it must appear to a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal, to award the motion to dismiss filed by defendant. Translation: it does not mean that the court must be certain that plaintiff will get more than $75,000. It means that the court won't dismiss the action unless the court is certain that plaintiff cannot get more than $75,000. So back to our example, what will happen? If defendant from Texas files a motion to dismiss stating that the plaintiff's case is not worth more than $75,000, the court will say, okay, prove it to a legal certainty, and we will award your motion to dismiss for lack of subject matter jurisdiction. Now, I want to go back real quick to the St. Paul Mercury test because I want to touch upon this tiny little part I left out on purpose. Not to ignore it, but just to discuss what was relevant at the time. But let's go through the small part too. The inability of a plaintiff to recover an amount adequate to give the court jurisdiction does not show his bad faith or oust the jurisdiction of the court. What does this mean? It means that events occurring subsequent to the institution of the lawsuit, which reduce the amount recoverable below the statutory limit, does not oust, does not revoke jurisdiction. So, Events occurring after the institution of the lawsuit that maybe lessens the ability of the plaintiff to recover that amount does not defeat jurisdiction, does not oust jurisdiction. Why? Because the jurisdictional amount is measured at the time the lawsuit is commenced. So subsequent reduction in the amount sought doesn't defeat jurisdiction if the original claim was made in good faith. Now, this next one is a similar concept, but it's a little different. Stay with me. This here addresses actual recovery at the end of the suit. Diversity of citizenship jurisdiction is not retroactively defeated by the fact that the amount actually recovered in the end is less than the jurisdictional amount alleged in the complaint. This comes from Rosado versus Weinman. So let me give you an example. A plaintiff alleges in good faith that she suffered $77,000 in damages. Obviously, we're pretending that diversity of citizenship is met. This should be enough to satisfy the amount in controversy requirement. Her good faith allegation is sufficient. So even if in the end the plaintiff only recovers $5,000, which is significantly less than the threshold requirement, right? This will still not affect subject matter jurisdiction retroactively. This is tested, so please include this in your outline. So circling back, where do we look to determine the amount in controversy? The amount in controversy is determined from the plaintiff's complaint and is met so long as it appears that the plaintiff has pleaded it in good faith. This is how I want you to write the rule on your exam, unless your professor or instructor says otherwise. The amount in controversy is determined from the plaintiff's complaint and is met so long as it appears that the plaintiff has pleaded it in good faith. Now, I had told you there was a lot to unpack, right? So we've covered the plaintiff's complaint determines part. Let's now talk about the amount in controversy itself. Hang in there. We're going to get to the juicy part soon, and then it will be over and you'll be able to relax for a little while. So what does the amount in controversy include and exclude? Let's talk first about what is included. Interest that forms a part of the claim itself, which is different than interest payable due to a delay in payment, is also part of the jurisdictional amount. Attorney's fees that are recoverable by contract or by statute are also considered part of the matter in controversy. And a punitive damage claim permitted under state substantive law may be used in meeting the dollar amount requirement also. Now, what does it exclude? Well, first, it excludes collateral consequences of a judgment. A good example is the right to payments of future installments on a disability policy. This may not be considered. So to give you a more detailed example, let's say that you sue because you were injured at a grocery store and you win this lawsuit. And the basis of this lawsuit is that because you were injured, now you're disabled. Now, if the court rules in your favor, you might be able to receive disability payments on top of your judgment from the grocery store. You might be able to apply for disability from the government or maybe a policy, an insurance policy you had. So this is money extra that you're getting as a collateral consequence of that judgment against that grocery store. That money cannot be considered to meet the jurisdictional amount for diversity. So collateral consequences, indirect consequences of the judgment may not be considered. Interest and cost are also excluded. That's actually in the statute itself. However, I want you to distinguish interest that constitutes a part of the claim itself, which is different than interest payable by virtue of a delay in payment from the defendant. Hang in there, guys. We're almost done. Next is the fun part. We're going to talk about aggregation of separate claims. This is also very highly tested, so let's tackle it and get it over with. Aggregation sometimes permits the amount in controversy in a case to be added together to satisfy the jurisdictional requirement of Section 1332. If aggregation is allowed, then there is original subject matter jurisdiction over any such claims. So let's explore what is allowed and what is not allowed. What does this look like? Let's see. Here is the first rule. For purposes of meeting the jurisdictional amount, so we're talking about diversity jurisdiction here. For purposes of meeting the jurisdictional amount, the amount in controversy, right? A single plaintiff may aggregate all her claims against a single defendant. And this is true regardless of the nature of the claims, even if these claims are unrelated. All right, so we have a plaintiff here with a claim for medical malpractice, a claim for breach of contract, and one for battery. And she's suing for $30,000, right, for the first claim, $30,000 for the second claim, and $17,000 for the third claim. This plaintiff here can aggregate her claims. We have a single plaintiff against a single defendant. Yes, plaintiff can aggregate her claims. No, these claims do not have to be related. Now, this is one that my students get a little confused on, so I want to cover it real quick. A plaintiff cannot aggregate different legal theories based on one injury. I'm not talking about different claims based on one set of facts. I'm talking about different legal theories based on a single injury. So, for example, plaintiff sues defendant on one injury. She suffered one single injury, one set of facts, one transaction, but she's using 3 different legal theories, maybe hoping that one will stick. Okay, negligence, breach of warranty, and strict liability. Each legal theory, not claim, is asking for $30,000. So in this case, the amount in controversy is $30,000. Why? Because it's one $30,000 injury demanded in 3 different ways. There is no aggregation because the plaintiff will only win on one of these. She's just testing them. She's seeing which one's going to stick. But there is only one injury, and if she wins, she will only receive $30,000. We know that from the onset because she will only win on one of these 3 theories. This does not meet the jurisdictional amount, and this cannot be aggregated. This is not aggregation of claims. Okay, so back to our original rule. A single plaintiff may aggregate all her claims against a single defendant, and this is true regardless of the nature of the claim, even if these claims are unrelated. We are clear on this, right? So a plaintiff who has an action against several defendants cannot aggregate her claims against them. If plaintiff here sues defendant 1 and defendant 2 for $50,000 each, we're going to have diversity of citizenship, right? But she's suing each defendant for $50,000. No aggregation. Why? Different defendants. We cannot do that. But distinguish. A plaintiff who has an action against several defendants can aggregate her claims against them, but only if the defendants are jointly liable to the plaintiff. Usually in your exam, they will indicate to you, they're pretty obvious about like joint liability, about whether 2 defendants are jointly liable to the plaintiff. So here we have a plaintiff from California suing defendant 1 and defendant 2. There's diversity of citizenship. She can aggregate these claims if these defendants are jointly liable to her. We're going to treat these 2 who have a joint liability as one entity. And there's a similar concept here. 2 or more plaintiffs cannot aggregate their claims against a single defendant, even if these claims are related, right? We want a single plaintiff against a single defendant. But again, distinguish, there's an exception. Several plaintiffs can aggregate their claims, but only if they are seeking to enforce a single title or right in which they have a common or undivided interest. That's the rule, that's the wording. So plaintiff 1 and plaintiff 2 are joint beneficiaries of a trust. For example, they're suing for $60,000 and $16,000 on an undivided interest. So we're going to treat them as one entity, right? This is allowed. And in your exam, they will give you the situation. They will tell you if this is the case. You won't have to guess. You will know if there's joint liability or if plaintiffs are suing on a single title or right. Now let's look at these scenarios side by side to avoid confusion. On the left, we have absolute nonsense. These scenarios are not aggregation. No. No to the no-no. Not aggregation of claims, not allowed. On the right, we have aggregation of claims. Notice one defendant against one plaintiff may aggregate her claims to meet the amount in controversy, even if these claims are unrelated, even if these claims do not arise from the same transaction or occurrence. And do not forget, we have some exceptions, right? When we have a single plaintiff suing two or more defendants who are jointly liable to her for all claims, meaning liability cannot be severed, then the law will allow aggregation. We're going to treat those two like a single entity for purposes of aggregation of claims. And similarly, several plaintiffs can aggregate their claims only if they are seeking to enforce a single title or right in which they have a common or undivided interest. So in these last two examples on the right, we are treating the multiple litigants as one entity because the type of cause of action calls for it. There's either a joint claim or joint liability that cannot be severed. Now, some students raise their hands during this part of my lectures and say, wait a minute, I thought claims needed to be related for aggregation. I remember covering something about these claims having to stem from a common nucleus of operative fact. Yes, you are remembering correctly, but that's not aggregation of claims, which leads me to my next point. Do not confuse aggregation of claims with supplemental jurisdiction. Let's distinguish aggregation of claims from supplemental jurisdiction. We're almost done, guys. Hang in there. Supplemental jurisdiction happens when a plaintiff meets the amount in controversy standing alone, and a second plaintiff is permitted to piggyback her claim, which does not meet requirements for federal subject matter jurisdiction, and join the lawsuit. That's a very informal way of putting it. Don't be using the word piggyback on your exam, please. Let's see what this looks like. Here is the rule for supplemental jurisdiction when it comes to diversity jurisdiction. If one plaintiff meets the amount in controversy standing alone, the second plaintiff can piggyback as long as the second plaintiff's claim arises out of the same facts as the main claim, stems from a common nucleus of operative fact as the main claim. 28 U.S. Code 1367 governs supplemental jurisdiction. Pretty much, and this is very summarized and incomplete explanation, if one plaintiff has a cause of action that meets federal subject matter requirements, it can be diversity, federal question, trademark law, copyright infringement, or any other federal jurisdictional basis, then a second plaintiff can add her claim and join the lawsuit, even if her claim does not meet the amount in controversy, in the case of diversity, or if it doesn't meet any other jurisdictional basis on its own. And this is if the second plaintiff's claim derives from a common nucleus of operative fact as the main claim that does meet jurisdictional requirements. To avoid confusion, let's do another side-by-side. This time, aggregation of claims versus supplemental jurisdiction. On the left, we have supplemental jurisdiction. One plaintiff meets the jurisdictional amount standing alone, and the second plaintiff, or several plaintiffs, can piggyback their claims that do not have independent basis for federal jurisdiction. They either do not meet the amount of controversy on diversity, or are not a federal question, or do not have any other basis for independent federal jurisdiction. On the right, we have aggregation of claims. Notice, one defendant against one plaintiff may aggregate her claims to meet the amount of controversy, even if these claims are unrelated. Notice that none of these two claims here meet the jurisdictional amount on their own, right? And do not forget that when we have a single plaintiff suing two or more defendants who are jointly liable to her for all claims, meaning liability cannot be severed, then the law will allow aggregation, right? Similarly, several plaintiffs can aggregate their claims only if they are seeking to enforce a single title or right in which they have a common or undivided interest. So, two things I want you to remember about supplemental jurisdiction when it comes to diversity. Claims that do not meet the amount in controversy requirement may invoke supplemental jurisdiction if they arise from the same nucleus of operative fact as the claim that met the jurisdictional amount. However, and this is very important, Supplemental jurisdiction cannot be used to override the complete diversity requirement. There must be diversity of citizenship. This last point is extremely important, and I go deep into it in my supplemental jurisdiction lesson. So please make sure you watch it. I promise to make it worth your while. Quick recap of most important points. The plaintiff's complaint determines the amount in controversy. When a plaintiff pleads in good faith an amount in controversy above the jurisdictional threshold, the court will recognize a rebuttable presumption that the amount in controversy requirement has been satisfied. Defendant now must prove to a legal certainty that plaintiff does not meet the amount in controversy if they're contesting it, right? If defendant is contesting it. And aggregation sometimes permits the amounts in controversy in a case to be added together to satisfy the jurisdictional requirement of Section 1332 diversity. All right, guys, we've reached the end of our lesson. You did it. Pat yourself on the back and take a break. You really did earn it. And if this is how you're feeling after this lesson, please email me at questions@jdsimplified.com.